The case, Stephen Marshall v. Winston Taylor and Brett Jones, was heard Thursday, February 21, 2019, for the Cleveland Marshall College of Law 50th Annual Moot Court Night. The case challenges the use of solitary confinement at Carson State Prison. The issues on appeal before the United States Supreme Court ask first whether prolonged social isolation and lack of environmental stimulation violates the Constitution's prohibition against cruel and unusual punishment. The second question was whether the use of solitary confinement on adolescents, tried and convicted as adults, when not in response to immediate emergencies, violates the Constitution's prohibition against cruel and unusual punishment. Counsel for the petitioner, Brent Cicero and Kevin Buryanek, argued that solitary confinement does violate the prohibition against cruel and unusual punishment.
This is a question of fact that may be inferred, as this court stated in Farmer v. Brennan, from the very fact that the risk was obvious. As my co-counsel has already explained, district courts around the country have had no problem concluding that subjecting inmates to 23 hours of confinement for months or years on end does in fact expose inmates to obvious risks of harm. This conclusion holds even greater weight when the inmate at issue is an adolescent particularly vulnerable to the effects of solitary confinement. Two district court cases are illuminated here. In VW v. Conway, the Northern District of New York granted injunctive relief to a class of 16 and 17-year-olds, prohibiting prison administrators from holding them in solitary confinement routinely.
Counsel for the respondent, Jessica Hamad and Malek Khawam, argued that solitary confinement is needed in prisons to help keep the peace.
Your Honors, solitary confinement is a necessary tool that enables prison officials to carry out their duties of preserving safety, internal order, and discipline. This court should affirm the decision of the 13th Circuit for two reasons. First, prolonged isolation, standing alone, is not a deprivation of any recognized basic human need. And second, in the conditions of confinement context, psychological harm alone cannot establish a prison official's deliberate indifference.
Hearing the case on behalf of the United States Supreme Court were Cleveland Marshall graduates the Honorable Donald C. Nugent of the United States District Court, Northern District of Ohio, and the Honorable John J. Russo of Cuyahoga County Court of Common Pleas. Joining them was Case Western Reserve University School of Law graduate, the Honorable Anne Claire Okar for Cleveland Municipal Court. Once both sides had argued their case, the court ruled in favor of the respondents, but agreed that the ruling was very difficult, as both sides had presented compelling arguments.
We could have been hung back there, but we had 3 minutes. All right? One for each side, one for the other. We are forced to pick a winning team.
We even argue with the moderator, we have to pick.
Exactly. We did it right. She made it good. And so this is how we gauge it, 51-49.
After court had been dismissed, judges stayed behind to offer suggestions and tips to the students before their competition. In an interview following Moot Court, Judge Okar explained how important Moot Court is for law students and the values it holds.
Well, first of all, it's really good to get in front of the courtroom. You don't always get that much experience in law school, although they're moving that way, in that direction. But most of the time, you're studying in class and not really in a court. So just to stand and sit in front of a courtroom is really great experience in any way you can get it. So Moot Court gives the opportunity to the students to do that, and so I think it's a really good experience for them.
Okay. What did you think about the students this evening and their presentation in Moot Court? How do you think both teams did?
Both were amazing. They had excellent knowledge of the material. They knew the case law. They were able to throw it right back at the judges with a case to defend their position. So I think they all were very well prepared, and they did a really great job.
Okay. The ruling was 51-49. How did you guys reach that? I know you said it was difficult.
It was difficult, and I think when we talked to the students after about some of the difficulties in the fact pattern, I think, for the petitioners, and so I think that probably had a lot to play into it. So it's hard sometimes to represent a position that doesn't always make complete sense because you don't have all the facts that you would like to and you would in real life. But so it was a really close call. I would say it was like 49.5 to 50.5. I mean, that's how close it was. Really, we were going back and forth for the short time we were able to deliberate.
Okay. And what other comments just in general about, the events that took place tonight would you want to comment on? Or any advice you'd want to give the team as they head for their next competition?
Just be confident, because I think they're really great, and I think they should each be confident in how well they've prepared themselves and go into the competition ready and stand there with confidence that they could really take, any of them can win next week.
For the team, in a roundtable discussion after the event, they expressed their opinions on their evening and their hopes for their trip to Boston that would follow that weekend for the competition.
Obviously happy with the verdict.
Okay.
I was a little thrown off by their questions very early on, so I changed my roadmap almost entirely right off the bat. But it was a fun experience. I was sweating the whole time I was up there.
Okay.
Very similar comments to my co-counsel Malek. Definitely when I left the podium, I left them a little of sweat, as I was telling you earlier. It was good. In the beginning, I was getting a lot of questions, and then it became cold. So I kind of freaked out a little and started kind of reading up on the where I'm at here. But other than that, it was all right.
Okay.
Well, clearly I had the hardest job keeping time and making sure that my phone didn't lock up so I can keep an eye on the timer. So that was very difficult, stressful, and I'm glad it's over.
Okay.
You guys go.
Oh, I am.
Okay.
Yeah. I don't know. Yeah. So beforehand, the first I'd say 2 or 3 hours before it, you're pretty nervous. I felt really nervous. But then you actually get in there, and then when you get up to the podium, it all just sort of disappears, and you're just doing what you've been doing for weeks, where you're sort of reciting what it is you want to say, and then when you get the question, you sort of think about, okay, so what are they asking me? What is the answer that I've worked on? And so it all just sort of, I don't know, it sort of flows, I guess.
Okay.
But yeah, I mean, the worst part is the anticipation, and then you do it, and it's only 15 minutes, and then it's over.
Okay.
Yeah, kind of just going off of what Kevin said, it's unbelievable how fast it actually goes. He argues for 15, I argue for 13, and I seriously felt like I was up there for a minute. Because after, as soon as I saw 5 minutes, it was just unbelievable that time went that fast. But, yeah, a little disappointed in the verdict and stuff, because it's against us. But we got really valuable tips from the judges afterwards, so it was nice to actually talk with a federal judge and Judge Russo, Cuyahoga County Police. So it was just a great experience, great night. So yeah.
Okay. So what are you hoping for when you guys go to Boston, other than obviously a win?
The food.
We heard they have the Sam Adams is better on tap there.
Okay.
I'm excited to have the opportunity to get up and argue. So both of our teams will at some point argue both sides of that issue.
Oh, okay.
So my particular argument is the petitioner side. So the other team wanted to have the opportunity to argue. So these guys, I was incredibly proud of them. They did a great job, and I'm just really looking forward to having an opportunity to get up and do it for real as well.
Great.
Yeah, I mean, this is my last year, and so this will be my last competition. So outside of doing well, I mean, I guess, success is just kind of how you feel about your argument, however the judges feel about it or whatever your score is. So I just kind of want to, I don't know, when I get up there, deliver it the way I want to deliver it, and if we go on, then cool. If not, then this will be mercifully over.
For Cleveland State University and the Cleveland Stater, I'm Victoria Shea.